Alrighty, good evening, everyone. Welcome to week 9 of administrative law. We're well and truly into the thick of the term, so I suspect most of you will be watching this on the recording later. So, hello to you from the past. Good to have you with us. So, this week we've got a few different grounds of review to go through. We're talking about statutory purpose and then relevant and irrelevant considerations, which are two separate grounds of review under the Act and do need to be thought of separately, but as we'll see, they do often pop up together. But so we'll talk through each of those, and we've got a hypothetical scenario as always to work through and identify some of the key ideas in action. One of the things that we talked last week about exam preparation, and I don't want to revisit too much of that. If you haven't seen it already, please do check that out. But one of the things that we talked about was preparing sort of scripts for yourself and I suppose honing your understanding of the relevant rules and cases and principles, doing as much of the prep work as you can in these coming weeks, so that by the time you get to the exam, all you have to do is identify which parts are relevant, and then just slot in your application and your discussion to the particular scenario. So for tonight's tutorial, I've got an example of how that might work, and we'll sort of talk through, here's parts of an answer that you could have pre-prepared already, and here's then parts that you would actually write up in the exam itself. So we'll see that in a bit of action. In terms of the grounds of review that we're thinking about this week, so statutory purpose, and then the relevant and irrelevant considerations. Um, they're they're not straightforward. There's a bit of nuance to each of them, but they're all there's not really too many tricks or traps to them that I really want you to be careful of, other than to say, just to remind ourselves that we're with administrative law and the judicial review process, we are really focusing on the decision making process and whether that process complies with the requirements of the Act and with general administrative decision making, rather than is the decision that we've arrived at the end of the day one that we agree with or not, or one that we think is right or not. And so just really bearing in mind, um, if we identify that there's a problem with the decision, that's great, but being able to spell out the reasons why that's a problem with reference to the different grounds of review that we're talking about. And so somewhere where that often pops up is relevant and irrelevant considerations, but in particular, the failure to consider a relevant consideration. And so when we think about Justice Mason's comments in Pecco Wallsend, and that's a really good judgment for highlighting what are the limits in what the court is willing to entertain in terms of deciding whether or not something was relevant, and then beyond that, deciding how much weight a decision maker should have placed on it if it was relevant. We just need to, in the judicial review process, be really mindful that we're not asking the court to overstep the boundary, that the separation between the judiciary and the executive, and really be mindful of what it is that we're asking the court to do and not do when we're entertaining a ground of review around a failure to consider a relevant consideration. So, on the one hand, that's a caution, but on the other hand, you can see that as an opportunity from an assessment perspective. You can see that as a chance to showcase your understanding of not only that ground of review, but the broader principles that underpin judicial review. And when we're thinking about preparation, when we're thinking about exam scripts. One thing that you might choose to do is just do up a few sentences on Justice Mason's comments in Pecco Wallsend, talking about the role of the court in deciding what's relevant and what's not, and their caution in dictating too much to the executive about what's relevant and what should be done with it. And then you can, if on the exam you get a question where the decision maker seems to have failed to consider something was relevant, or there's issues around that, you can plug that discussion in and integrate it into your answer to highlight, look, we've identified that there's this problem. We've identified that there's this thing that was really relevant. And we think that the failure to consider that has caused a problem with the process by which the decision was made. But at the same time, we very much recognize Justice Mason's comments, and in asking the decision maker, in identifying that there was a problem with the process, we're not asking the court to intervene and tell the decision maker, look, you should have looked at A, B, and C, and the fact that you didn't put any weight on B is a problem, and all that sort of stuff. So it's something to be mindful of, but it's also a real opportunity to showcase your application and understanding, and to get some marks on that application criteria for the exam. So without further ado, I think the best thing for us to do is jump straight into this week's question, and we can work through some of those ideas in action. Yeah. So tonight's tutorial question, we've got the Civil Aviation Act, and a scenario where John has a lot of experience in the aviation industry. He's been working with big airlines, and then he has decided to split away and do his own thing and run a little charter flight company in the Whitsundays. In order to do that, he needs to get an air operator certificate. He makes that he makes that application, and it is rejected. And so he's seeking advice around whether he can review that decision, and if so, why. So as always, I'll throw it over to you guys for your initial thoughts and reactions, and then we can consolidate those ideas and start to look at how we might craft that into an answer. So we've got someone approaching us with a problem with an administrative decision, or a decision letter that they've received. What's the first thing that we're thinking? What's the first thing that we're asking ourselves? What's the first thing I'm going to ask you on the exam?
Is judicial review available?
Yep, absolutely. I told you guys in week 5, you'll be sick of this question by the exam. Is it available? And the answer is probably yes, but the why is important. Why is judicial review available here?
It's of administrative nature. It's all of those four things. Definitive. The decision is definitive. And it's not excluded under a schedule, and I don't know the other one.
Made under an enactment.
Yeah.
So how do we know that this is an administrative decision?
I would have just said it's a Commonwealth Act, and you've made an application to receive something for a license, and you've been rejected.
Yeah. So we're thinking more in terms of, what are the types of features that indicate to us that a decision is of administrative character. I think you're on the right track, but specifically we're thinking about this isn't broad policy or something that's being done by the legislature, as you say. This is an action that's been undertaken by the executive. It's the specific application of broad law to a particular individual, in this case, his application, as you said, Ian. We're thinking about, it's clearly not judicial because we're not going to the judicial review process yet. And so by that process of elimination, we can identify that it's of administrative character. As you said, Ian, it's Commonwealth legislation. It's been made under a Commonwealth enactment, specifically section 27, I think. Yes, 27. And so being in Commonwealth legislation, we're dealing with the Commonwealth jurisdiction, and in particular thinking of filing with Federal Circuit Court or Federal and Family Court. And then, as you said, Charlize, it's not excluded under the Act, and we've got a decision with a degree of finality. What else do we need to there's one more thing to really think about in terms of judicial review availability.
Standing.
Yep, absolutely. Do you reckon John's got standing? Yep.
Yes, because his personal interests or he's been affected, and it's much more than just mere emotional upset.
Yes, absolutely. So more than a mere intellectual or emotional concern, and specifically here thinking about this one, his material interests in terms of his ability to obtain this certificate and conduct a business have been affected by the decision. Excellent. Alrighty. So we're satisfied that John can access judicial review. Now let's think about which grounds of review might be available to us. So initial thoughts and reactions.
Well, the first one, if you look at the findings of fact, you have no experience operating an airline company in the Whitsundays would not be a provision that would be outside the powers of the authorised person, I would imagine.
In what sense?
Grounds of an unauthorised act.
As in, so sorry, say that again. In looking at the decision.
Well, I don't imagine that having experience operating an airline company in the Whitsundays would be listed as one of his things that he would have to have under the Act to get a license. Just the first one.
So that's the first finding of fact. Let's focus. Obviously, the findings of fact feed into the decisions themselves. But okay, no, sorry, I'm looking in the wrong spot. I was looking at finding of fact, but yeah, the second sentence of the first part of the decision. Sorry, yep. So supported by the fact that you've got no experience operating airlines in the Whitsundays. So here's the thing, right? So section 28 of the Act sets out the things that the authority needs to look at or consider when deciding if they're satisfied that the air operating certificate should be issued or not. And trying to find the section number. So section 28, 1B, paragraph 4, key personnel in the organisation have appropriate experience in air operations to conduct or carry out the air operations safely. So we'll talk about these in more detail in a minute, but thinking about the scope of how detailed versus how broad the decision makers should be looking at, they're empowered under the Act to be thinking about, or they should be thinking about, appropriate experience, but whether that needs to specifically be experience in the Whitsundays or not is something to be thinking about. Yep. So this sort of the decision makers take an issue with a lack of experience in the Whitsunday specifically, and so we can have a think about whether that's problematic or not. Yep, absolutely. What else?
It looks like the decision makers taken into account some irrelevant considerations. So it talks about the evidence that an independent assessment of hanger number 5555, when it's the incorrect hanger number, the correct one is 2382.
Yeah.
And also in the evidence relied on media reports of a recent scandal involving the former employer, Big Cat Airlines. And in the findings of fact, it also refers to the incorrect hanger number, that 45's not complying with safety requirements, being too small, no locking mechanism on the hanger door, which is all irrelevant because it's the incorrect hanger. So yeah, I think there's some elements there around the fact that the decision maker took some irrelevant considerations.
Yep. So thinking about the wrong hanger for starters, and then particular issues with that hanger, and then also thinking about the attention that was paid to media and media headlines and those sorts of things. Yep. What else?
Probably statutory purpose, because the purpose of the statutory is not to investigate each person's personal life, and I think they've gone into that. It's not, like you said, it's not relevant, but it's not the purpose of the statutory as well.
Okay, yeah. What is the purpose of the Act?
Is to make sure that they are compliant, in a sense they have a they comply with certain stuff in like their commercial pilot license, health and safety, that type of stuff, but not
Yeah, and why is that? Why are those things important? Why has Parliament given the executive or the safety authority the ability to look into those things and to require compliance with those factors?
Because they'll be out flying public people.
Yeah.
You know, but just because you have to have a license to fly.
Yeah. What does Section 3A of the Act say?
It's in the preventing aviation accidents and incidents.
Yep. So the main object of the Act is to promote safety and to avoid accidents, right? And so when we're thinking about why does the authority have the power to require people to have this certificate, and in order to get the certificate comply with all these safety features, it's because the purpose of the power is to promote safety. So yeah, absolutely, you're right, Charlize, in terms of the broad ideas. So we've covered the main things. There's a few more details and specifics that we'll talk through, but good identification of the key things being, for one, this seems to be a problem with the purpose for which the power was exercised, and then issues with failing to consider some relevant considerations, and on the flip side, considering some things that might be irrelevant. So we'll talk through each of those in turn. But before we do that, one thing that I did want to talk about in terms of the way that you structure your discussion and structure, particularly structure your exam answer, but it helps with these tutorials as well, I think. I was asked this question later last week in terms of, for the exam, how should you structure your answers in terms of, do you talk about each different ground of review separately? Do you talk through each issue together? How should you go about it? And my answer is, the most important thing is that your answer is clear and follows some kind of logical structure that arrives at a sensible conclusion. So that's the most important thing. And the pathway that you take to get there, I'm a bit more agnostic on. Most of the time, for most people, you will find it easiest to achieve that clarity by talking through each ground of review separately. And I think especially given the time constraints of the exam and given the way that we sort of structure our thinking in this unit overall, as a default, my suggestion is talk about each ground of review separately. If you were feeling really comfortable with it, if the way that the problems manifest in a particular scenario, etc., another approach might be you take each element of the decision and pick apart all the problems with that. And within that, there might be multiple grounds of review that are relevant, and you talk through all the problems together. I'm happy with that as well. I think most of the time it will be easier to structure by ground of review, but if you structure by issue or part of the decision, that's completely fine. And so, for example, taking tonight's tutorial as an example, they've given 3 reasons for their decision. So the first one, not satisfied you can comply with the safety rules. Second, not satisfied that the organization meets the requirements. And then thirdly, not a person of good character. You could talk through, so A, they've said that you can't comply with the safety rules. There's issues with that. For one, they've failed to consider relevant considerations, blah, blah, blah. For 2, they've considered irrelevant things, da, 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 da. The second reason that they've given is they're not satisfied with the organization. Here are the problems with that, all the different grounds of review. The third thing they've said is you're not a person of good character. Here's all the problems and grounds of review relating to that. You could do it that way, or you could do it, here's the first ground of review, and here's how that infects all 3 reasons that they've given, or whichever subset is relevant. Second ground of review, relevant considerations that have been failed to be taken into account. Here's how it is problematic across the different reasons. Either's fine. I think you'll have an easier time going by grounds of review. And so we'll do our discussion of that like that today. But I suppose just to let you know that if you were looking at this and instinctively you were going a different way, that's not wrong. And I'm happy for you to do it in that different way. But yeah, it's more a clarity and developing a structure that flows that's of most important. So with that in mind, we'll talk by ground of review for the rest of tonight's tutorial. And I think we should start off with statutory purpose with the first one. So I'll share my screen with you. Let's say you've done all your great exam preparation. You've compiled your notes. You're really feeling really comfortable with the statutory purpose grounds of review. Something that you could get yourself in a position to do is to have written up a script for yourself like this, where you have a paragraph that outlines, here's the basic set of rules and principles relating to this particular ground of review. And I've just done it like this because PowerPoint doesn't do footnotes, but in your notes, you would do this as properly footnoted, compliant with AGLC, and same with the cases and things like that. But talking through the different elements. So first, what's the ground of review? What are the key things that we need to be thinking about? Key principle in terms of who bears the onus of proof, and then set yourself up for the discussion and the application that is to follow. So in this scenario, what's the primary legislation? Why does it give, what's the power that it gives the decision maker? What can they do? Why are they able to do that? And then how, based on the facts that we know, is what the decision maker's done inconsistent, or why might it be inconsistent with the purpose the power was given for? So just bearing this as a rough structure in mind, we've talked through already that the purpose of the power is for safety, but can we elaborate a little bit more on the purpose for which the power was exercised, and particularly thinking about the fact that we are going to bear the onus of proving this ulterior motive or this other purpose that was used? What do we think might be the issue here?
The purpose of his powers is to make sure everyone complies with the health and safety, and
Yep.
with the license requirements and stuff like that.
Yep. So the purpose of the power is for safety. If we're raising issue or having some concerns that in this instance the power wasn't used for safety, it was used for something else, what might that something else be, and how do we prove that? Or can't we? Are there issues with our ability to prove that?
Well, the character, the inference of not being a good character, you could prove, because he states there specifically that he was responsible for it. You could prove that he was never charged with anything with that, because they said earlier in the thing that he was cleared to not be involved in it. It wasn't even when he was there, but when he was there for that 5 years, everything was fine. It excelled. So you could certainly knock that one out of the park.
Okay, so we can demonstrate that. So the decision maker has said you're of poor character because you were involved in this data misuse, and we can prove that that's an unfair accusation because he wasn't part of that. But what does that tell us about the purpose for which the power was used?
Well, it's more subjective and not objective, I suppose.
Yep. So it's they've seemed to have focused on things that aren't necessarily related to safety. Yeah. Were you gonna? Yeah, I saw you come off mute as well, Charlize. Did you want to add something too?
I just said it's gone beyond the power that was delegated to him. He was not his power doesn't include going into personal character and stuff like that, does it? Sorry, I have not read this whole thing, so I'm just going off blindly.
Yeah, no, that's a good. Well, and yeah, there are thinking about previous weeks and other grounds of review. Yeah, there are sort of other things that we can be drawing in as well. But I think, yeah, the core thing being there seems to be this sort of deviation down the pathway of casting aspersions about John's character, and that makes us wonder, okay, well, why have they done that? That seems like a weird thing to have done. What's difficult for us, yes, we can prove that he wasn't part of that issue, and so it's an accusation that is quite groundless. But
Sorry. interrupt, maybe like procedural impropriety in the sense of what's the procedure that he's followed to find that out? Is that part of the procedure?
Well, I mean, let's if we've got time at the end, let's circle back and think about other grounds of review that we've talked about in other weeks. More what I'm getting at the moment is thinking about if we're going to raise an issue with statutory purpose, we need to be able to demonstrate as a question of fact what the other purpose was for. And so we've got to have some evidence of the other purpose that the decision maker had in mind, or that other goal that they were trying to achieve, to contrast that with the purpose of safety, which is outlined in the Act. That's difficult for us at the moment. We've got these problems with, look, they've gone down this character route, and that seems strange, but it's difficult for us to know exactly why that was. It might be, and we don't know, but it might be that the person who made the decision, they were one of the people whose data was was sold or misused. And so, there are problems with, the purpose wasn't for safety. The purpose was to get him back, or get anyone who associated with big airlines, get them back, get even, get revenge, whatever. We don't know that based on the facts. And it's important to demonstrate our knowledge and understanding of those evidentiary requirements. It's important that we're able to have a critical and nuanced discussion of the law in this space, in order to develop a good argument. So what I might do, I'll share the screen again. And so this is our template that we've got in our exam notes, and then we get into the exam and we fill in the extra bits. So this top bit is exactly the same as in the previous slide. What have we done? We've filled in the details from the Act, and then we've suggested, okay, what might be the purpose? So there might be some kind of ulterior motive, and as we've identified, it's the comments about John's poor character that suggest that there's something else going on. However, at the moment where we are not operating in an environment of perfect information, we don't necessarily have the evidence that we need to satisfy the requirement per Municipal Council of Sydney. And so what can we do? Maybe it's an FOI request, to try and get some more information about how the decision was made. Maybe, the reasons, we argue that the reasons weren't quite good enough or quite clear enough. They don't outline the actual reasons behind the decision. And so we try and get better reasons. Whatever it is, we know that we're missing something. And from the perspective of an exam answer, I think we might have talked this in the past. If you feel like you don't quite have all the information you need, that's fine. You include that in your answer. You say, look, I think there's a gap, but what you need to do is be really clear about what the gap is, why it matters, and how, if you got that little bit more information, how does that impact on your answer? So in this instance, we're identifying what the gap is. We can't actually prove what the purpose was. Why does it matter? Because the onus is on us to prove what the purpose was. And how do we go about it? Well, if we get information that is confirming our suspicion, then we actually have very good chances of demonstrating this different purpose and succeeding on that ground of review. So it's fine if you feel like you don't have all the information. We rarely do in legal practice. But what really matters is being able to identify, what are the next steps from here? What do we need? And why is that going to be important? So that's statutory purpose. And I think that, subject to getting more information, we potentially have a good argument that there has been an issue, that the decision-making power to reject the application has been used for a purpose other than that for which the power was conferred, i.e. airline safety, but we do need that little bit more information. Any questions about statutory purpose before we move on to the other grounds of review? Sorry, I think I might have frozen there. I was just asking if there's any other questions about statutory purpose before we move on to the next grounds of review. No? Okay. Let's talk about relevant considerations next. So what were some of the things that we think should have been included or should have been paid attention to, but weren't? Earlier, so Craig talked about the problem with not looking at the correct hanger. So the sort of a relevant consideration would have been evaluating the proposal based on the correct hanger, which is 2382. Is there anything else that the decision maker probably should have been looking at that they missed?
Would they have had to include the actual report to see where it fell down? I mean, procedural fairness under this would be that there are issues that he can fix, not necessarily that he can just have it wiped off that he can't get the license for it. I mean, there's things that he could fix. He could change hangers, he can put locks on doors. And I still don't see how he can judge the aeroplane not meeting the required standards of safety either, because
let's
talk in the inspection of the plane.
So let's focus on, let's not worry about procedural fairness till next week. And let's also not necessarily worry just yet about whether there are things that he could do to fix it, because the powers given under the Act are may issue, so not necessarily a power or a requirement to give someone an opportunity if it's determined that they're falling short or falling slightly short. It's not necessarily a requirement that they be given the opportunity to fix it before they get that no. But in terms of the looking at whether the plane meets all the requirements, all the required standards of safety. So we're thinking perhaps that the decision maker should have paid closer attention or actually looked at the plane in order to arrive at that conclusion. I can see that. What else?
Jacob, should we be looking at Section 28, which talks about the things that that says that CASA must issue an AOC if satisfied about certain matters? Are they the sort of things we need to be looking at in determining whether the decision maker failed to take relevant matters, because they look like they are sort of relevant matters that must be taken into consideration under that Section 28?
Yeah, so thinking about, and this really plays nicely into Justice Mason's comments around, where is the line between judiciary and executive in this ground of review, where the statute sets out considerations or things that the decision maker needs to be looking at. That's really useful from a judicial review perspective, because it helps us make the argument to the court, look, these are the things that the decision maker should have focused on. And we're not just saying that as a, look, we think it would be great. We're saying that based on the legislature has dictated to the executive, these are the things that need to be considered. So it from the perspective of separation of powers, it helps it helps the court feel better that they're not just going off on their own of their own accord and dictating to the executive what they should be looking at. It's actually with reference to statute and what the the democratically elected parliament has said needs to be considered. So it gives it a bit more clout. So yeah, thinking about this act in particular, using Section 28 as a starting point is a really useful approach. Were there parts of the act that really leapt out to you as being potentially important?
Yeah, I was looking at a few of them. Section, I think 28, 1B1 about the organisation is suitable to ensure that AOC operations can be conducted or carried out safely, having regard to the nature of the AOC operations. Because I was thinking there that, if it was a small operation, 2 people operation, that it was still feasible to be carried out safely, because it's it just because it's on a small scale doesn't mean it won't be necessarily unsafe. And there was a few others that I highlighted in there.
Yeah, absolutely. And
well.
I think, yeah, I was going to say, I would suspect that the others that you have highlighted probably point to, they all address a similar issue around the decision maker has really focused on the size of the personnel, in that it's only 2 people, but they have failed to consider the corresponding issue of the size of the operation, in that, yes, it's a small number of personnel, but it's a correspondingly small operation. They're just doing these short little joy flights. It's not like a giant commercial 50 flights a day, Qantas, Jetstar, whatever. And so with reference to things like paragraph 1 that you identified, and then also a couple of the others around, so thinking about the paragraph 3, the organisation has a sufficient number of suitably qualified and competent employees. What's a sufficient number? A sufficient number for a small little charter company or airline is going to be very different to a big interstate operation. And so thinking about those sorts of things in particular is because we can point to those parts of the legislation that specifically spell out, you need to be thinking about this. These need to be the kinds of things that the decision maker is paying attention to. The fact that the decision maker seems to have failed to consider the size of the operation and the scope of what they're trying to do, we can raise that as a potential problem. Yeah, absolutely. What else?
You could say that their qualifications are current and appropriate, as opposed and fit the act there. So
Yep. Well, and I think now is actually a really good opportunity for us to revisit your earlier point as well, Ian, about his experience in the Whitsundays. So did you want to, I don't want to put you on the spot. Did you want to talk more about that particular element?
He's got a current license, and he has had a lot of experience in running that other company, which was doing the exact same thing, but just not in the Whitsundays. So the way that's a subjective statement saying we don't have enough experience in flying in the Whitsundays. That would be like saying a pilot that can fly to England can't fly to France. It's just a bit strange.
Yep. Yeah, absolutely. So, what they've said is technically true, but it fails to consider. They've said you don't have any experience in the Whitsundays. Yes, that might be right, but they have failed to consider his extensive experience in a big commercial airline for, what was it, 30 years in the facts. Over 30 years experience right throughout a commercial airline operation, from handler to
Yeah.
pilot to sort of chief operating officer. So
I was going to say, you have experience from the ground up and was
Yep.
working through the whole thing. Yeah.
yeah, absolutely. And so we'd have the scope to argue that they've failed to consider this wealth of experience that he's bringing to the table. Sure, he might not have done this specific thing, but over the course of his tenure working in the airline industry, he's picked up plenty of other experience that the decision maker could have considered. Now, here's the tricky part, and here's the part where Justice Mason would want us to be very careful. We would be drawing the line. We wouldn't be saying, well, we wouldn't be asking the court to say that the decision maker should have said, well, he's got 30 years experience. It doesn't matter that he's not done anything in the Whitsundays. It might be that there is something unique or particular about the Whitsundays flight conditions that makes it important that a person has experience there. I don't know what that would be. Maybe there's magnetic interference in the Whitsundays, or the vulnerability to tropical storms and cyclones makes it, important that a person has had experience in that region, in order for the authority to feel comfortable that they've got that sufficient experience and expertise. So it's not just the court saying, well, look, he's got 30 years experience, therefore you have to give it to him. It's more nuanced than that, and it's the court saying, look, it's got to at least be in the mix of things that are being considered. Yes, he hasn't got experience in this particular region, and there might well be good reasons why there needs to be a focus, but the decision maker hasn't necessarily given those good reasons. And in the absence of that, thinking about the broader experience that John's bringing to the table ought to be at least part of the mix, and ought to be part of the things that the decision maker was considering. It's then up to the decision maker to then decide how much weight to put on that. How valuable is 30 years experience in the industry versus a lack of experience in a particular region? Maybe it matters, maybe it doesn't, and it's not for the court specifically to dictate how much that matters, but it is open to the court to say, look, it's a problem that this wasn't even considered. It wasn't even in the mix of factors. Does that distinction make sense?
Could you ask in disclosure for them to produce why the Whitsundays would hold such an important thing?
You might argue that if there's a good reason for it, it's a problem that the reasons for decision don't outline it, and it might well be that there is no good reason. In which case, we'll find that out too. It might be that, based on our earlier concerns around statutory purpose, that the decision maker, just has it out for John, and they've taken an overly narrow focus on the Whitsundays experience for no good reason at all. We just don't know based on the facts. But yeah, as part of the understanding better understanding the decision-making process, that's something that might shake out, or it might be that there is actually no basis for it. Just have to see. Let's talk about irrelevant considerations then. So we've had concerns that, in particular, the the wrong hanger was looked at. And then also we've raised the concerns already about this focus on his poor character or lack of good character, and that being an issue as well. Now, is the mere presence of an irrelevant consideration enough to cause a problem with the decision?
No, it has to be the dominating, actuating reason for the decision.
Yep.
Klein and Domus Proprietary Limited.
Yep, absolutely. So we've sort of got our work cut out for us a little bit. It's not just enough to identify, look, here are some things that were mentioned in the decision making that are irrelevant. We've got to go that next step and actually say, not only were they irrelevant, but they dominated the reasoning for the decision. Do we think that we could do that here?
Well, could you include that it was irrelevant and there's no evidence of it? What those are?
They would be separate. So you mean, for example, the issues with the data scandal, when you actually look into it, he wasn't involved in it anyway.
Well, there's the wrong hanger and the character assassination. So there's no evidence of any of those things, and there are relevant considerations as well.
Yeah. So there you would, in a full and complete exam answer, you could raise them, but one wouldn't necessarily help you prove the other. You know, from the perspective of an irrelevant consideration needing to be the dominating reason for the decision, the fact that there's no evidence of it doesn't necessarily help you show that it dominated the reasons. So it might well be the case, but it's not. It's not an automatic thing.
A combination between the irrelevant considerations and the relevant ones. That those are irrelevant, and the ones that they've got licenses and sufficient number to do it, that's all the relevant ones, and the two of them work opposite each other.
Do you mean just for this question or in general?
No, in general, I thought that's how it worked.
So they're listed separately in the Act, and to the extent that any of these grounds of review are completely separate, there's always a bit of blurring and overlap between them all. And these are two grounds of review that often, they often will be two sides of the same coin, absolutely. But they need to be treated separately just because there was an irrelevant consideration doesn't necessarily mean that the decision maker failed to consider relevant things as well. I'm talking in general terms here. And equally, just because a decision maker failed to consider a relevant consideration doesn't mean that they considered irrelevant things in its place. And the reason why that distinction is possible is because for the irrelevant consideration to be problematic, it needs to be the dominating reason for the decision. So you could have, in theory, a decision maker who, you've got a list of things that are relevant and the decision maker has considered them all. So, they haven't failed to consider anything that is relevant, but some irrelevant consideration has come in over the top and sort of, dominated, wiped out all the relevant things that were considered, but just in the final decision, weren't the key reasoning behind it all. In this instance, I think that you probably, the two do work well together, but I'm just cautioning that it's not an automatic thing.
Sorry, Jacob. I was just trying to figure out how to sort of come to a conclusion about the dominating reason
For this scenario?
Yeah, and whether you go back to the actual decision reasons that was stated, those three reasons again, and use those as to sort of analyze those three reasons, that each of those are predominantly based on irrelevant considerations or dominant, because it talks about it's supported by the fact that you have no experience operating airlines on Whitsundays, and not satisfied that your organisation meets requirements to safely operate. Specifically, they've got nowhere to safely store the aircraft, which is not true. An operating personnel of 2 staff is too small, and they're not a person of good character. So is that a sort of method where we could go back to the actual reasons stated for the decision and try and make a conclusion?
Yeah, well, so there's a reason why I saved irrelevant considerations for last in our discussion here. And there's a reason why, I'm saying in this instance, I think the failure to consider relevant considerations pairs really well with the irrelevant considerations. Is when we look through those reasons, having raised the problems with the failure to consider relevant considerations, and when we raise potential issues with the statutory purpose, once we kind of pull all those issues out, all we're left with are irrelevant considerations. And so by that sort of process of elimination, they've dominated the reasoning, because that's all that's left. If we can establish that there are issues with the failure to consider the right hanger, and the issues potentially with the reasons for looking at his poor character or whatever, all that we're left with is irrelevant considerations. So yeah, it's a way of doing it. Sometimes it will be in itself, it will emerge as the dominating reason. For example, when it's the only reason that's given. But yeah, otherwise we can sort of look at how it factors in with other problems with the decision-making process as well.
Thank you.
Yeah, no, that's all good. Any other questions?
Would you be able to hammer him over the fact that he's listed that as evidence and findings of fact when it's neither of those?
As in?
Well, normally they list the reasons why, but he's actually listed it as evidence and findings of fact, and they don't actually purport to be those.
I'm just, as in, so the way that the reasons for decision is set out, where it lists the evidence relied on and the findings of fact, problematic as those findings may be, or baseless as those findings may be. Is that what you mean?
Yeah, that's the way he's listed them. And if it goes to court, that's how the court's going to read it. These are actually the evidence and then the findings of fact. And if you can disprove the facts and show that there's no evidence, then it's got to point to an incorrect decision, you would think.
Well, so that's in the final minute. I think we can circle back to some of the other grounds of review that you've raised and that Charlize raised earlier as well. So potentially, yeah, we're thinking about no evidence, which we talked about in week 6. In particular, we might be thinking about the issues around not looking at the right hanger as being pointing to a reliance on a non-existent fact. Thinking about some of the issues that Charlize raised as well around failure to follow proper procedures. We don't have the detail in the legislation that we've been given, whether the decision maker has particular procedures that they have to follow in terms of how they evaluate the proposal, how they conduct investigations around whether the hanger is safe and those sorts of issues as well. But if we had that detail and if there were issues with that, then potentially those are other grounds of review that are open to us as well. Absolutely. And so, as we progress through the term and we get more and more of these grounds of review stacking and overlapping on the top of each other. We'll talk more about how we can identify grounds of review that tend to cluster together and that it tends to make sense to discuss in conjunction and playing off one another. But for now, we're just going to focus on discussing them in discrete so that we can get the fundamentals down pat. And then as we get into week 11, week 12, we'll work on putting them together a bit more.
Okay, because what I think Craig was trying to get at was that you list out all the different things, and there might be 3 or 4 of them. How do you then base your argument on the most relevant ground for review? Like if there's 5 or 6,
you get them all. As in, like, if you were taking this to review, how would you pick which grounds of review to present for judicial review?
Well, no, I was thinking more with the relevant considerations. Like if you said that had to be the most important one, if you considered that to be it.
Mm-hmm.
But what I was saying is if you can point out 4 or 5, you sort of just knocking the decision down bit by bit, aren't you?
You're knocking the decision down bit by bit, but then all you're left with is irrelevant stuff, which then also gets knocked down, is what I'm saying. So so for example, the thinking about the so they've given 3 reasons, right? They're not satisfied that they'll comply with safety rules because he doesn't have experience operating the airlines in the Whitsundays. If we can successfully argue that they've failed to consider the relevant consideration that he's got 30 years experience in the airline industry, then that no longer stands as a reason to support the decision. The second one doesn't safely fails to meet the requirements because they don't have the safe place to store it. They've looked at the wrong hangar. Again, they've failed to consider something that's relevant. And the operating personnel are too small. Again, they've failed to consider the relevant consideration that it's a small operation to begin with. Then all we're left with is to justify the decision or to stand as a reason for the decision is that he's not a person of good character. We might be able to argue that that goes against statutory purpose. It depends on the evidence. But even if we don't, if that's all that stands as the reason for the decision, then we can say that that's irrelevant. There's nothing in the Act that says that the decision maker can look at the person's character. It's irrelevant. And having successfully rebutted the other 2 reasons, that's the only thing that's left to justify the original decision. And we can say, well, if that's all that's left, that's what's dominating the remaining decision, and we can show that that's irrelevant.
So in your application to the federal court, you list them as you go through, like you would?
Well, so I suppose this is why I'm saying when we think structurally, thinking about the difference between listing each ground of review and why it matters, or listing the different reasons for the decision, and within that, the grounds of review that apply to each or demonstrate the issues with each. And
yes, I'm not talking about the exam at this point. I've just wanted to know in theory, in practice, is that how you would list your application to the federal court? Because you've got to substantiate the grounds of review, so you would list them like that. That's all.
In practice, I would go by based on the reasons given in the decision letter, and I would structure basis. I would say, look, they've based it on the first reason, and then here's all the reasons why that's an issue. Here's the second reason they've given, blah, blah, blah. What I'm saying is, for the exam perspective, given that you've got such a limited time, it's easier to flip it the other way and focus just on structuring by ground of review. But yeah,
absolutely.
In practice, I would generally go the other way. Excellent. Well, we've run over time, I'm afraid. So thank you all for sticking around. Have a great week. Remember, your reflection tasks are due on Friday evening, 5 p.m. Queensland time. So looking forward to having those come in. And other than that, have a great week, everyone, and we'll see you next week. Thank you.